Hi everyone, I'm Maggie LaBranch-Gonzales, and I'm an attorney with Litherland, Kennedy and Associates. We're an estate planning and elder care law firm located in sunny Campbell, California. Now I wanted to talk to you a little bit about some exciting news. Did you know that National Estate Planning Awareness Week is coming up? Stunned silence. I'm sure many of you were sitting on the edge of your seat for that one. So October 19th begins National Estate Planning Awareness Month, and I want to take a little bit of time to talk about your estate plan. First of all, do you have one? Crickets. Okay, if you don't have an estate plan, ask yourself a few questions. Are you over the age of 18? Okay. Do you care about where all of your assets go when you pass away? Do you care about who would be managing your assets if you're either incapacitated or you've passed away? Most people have a preference. Do you want to have some sort of preference about your end of life decisions? I'd say most people have a preference. Do you have over $166,250 in either real property or other assets? Probably. If any of those questions were any of those questions you answered yes, then absolutely, you need an estate plan. Or maybe you already have an estate plan, but when was the last time that you reviewed it? Has it been 5, 10, 15, 20 years? Then it's probably time that you dust it off and come into the office for a little review. We can review the estate plan that we've drafted, or we can review estate plans that were drafted somewhere else. And guess what? We don't charge you to review them. Just a little tidbit. So why should we even have a comprehensive estate plan in the first place? Well, it's private. If you have a trust, you don't have to go to court. Nothing gets administered in court. There's no living probate, the conservatorship, and there's no death probate. Everything stays private. So all the beneficiary information, all the information about your assets, how much they're inheriting, nobody needs to know about it. You're avoiding all those court fees, publication and bond fees, attorney fees. Those darn attorneys, they're always around, right? We can say and give preferences to where we're leaving our money, who we're having as our trustees, who are making our financial and medical decisions. If you don't have an estate plan, you're not going to have a preference, and the judge gets to decide who these people are. Where is your money going? California already has a plan. That's why we need a comprehensive estate plan. Well, then the question is, well, what does it include? I'll just talk about the big documents. There's really a couple of big documents. There's some other documents, but the big ones, the trust. Well, a trust is going to say who the trustees are, who's going to manage the assets if you're incapacitated or you've passed away. It's going to say how everything is being distributed. It has a couple of other big things, but that's really it, right? The trust is going to hold and manage all of your assets. There's a pour of a will. Now think of the pour of a will as the teammate to the trust. They work together. The pour of a will does a couple things. It revokes other wills or things that may have been considered a will, names guardians for your minor children if you have minor children, and it also is going to say, hey, everything I own belongs to my trust. That way, if something wasn't in the trust, fell out of trust, doesn't have a joint owner, or there's no beneficiary listed, and then it can pour it over into the trust. And that way we avoid the big probate. So that's why they're teammates that work together. Another big important document is the durable power of attorney, sometimes referred to as the property power of attorney or the financial power of attorney. The reason you have that is it manages non-trust assets. So what's a good example of a non-trust asset? Your retirement accounts, IRAs, 401ks, pensions. You need to take your IRA contributions, but you don't even remember you have an IRA. Someone can do that for you. That's what the power of attorney is. And then finally, you have your advanced healthcare directive, your healthcare power of attorney, and your HIPAA. They work together like teammates. So the healthcare power of attorney that is going to nominate an agent to make your medical decisions. And it's also going to give them an idea about what your decision might be. Do you want to stay on life support? Do you not want to stay on life support? Do you want to be cremated or not cremated? How do you feel about donating your organs? If you don't say a preference, how's anybody going to know what you've decided? Then you have your HIPAA. So now your HIPAA release is going to authorize the doctor to talk to your agent, right? They can give the test results. What room are you staying in at the hospital? That sort of a thing. The healthcare directive, the power of attorney, is going to allow the agent to talk to the doctor. So you really need that two-way street. That's why you have both documents. So you can understand very briefly why this is a really exciting week for us. We want you to feel empowered to have an estate plan, giving you that peace of mind, understanding what your estate plan says. Have you reviewed it in a while? Have things changed? It's very important. And so if you haven't already signed up for our client review workshop, or if you don't have an estate plan, sign up for our webinar, for our Living Trust webinar. And that way we go over everything and the importance of why you need it. If you're a client, you can always call our office and schedule an appointment. Thank you. Bye.